Okay, it is 9:17 Central Time, and that was my cue for getting started. I hope everyone who was participating in the earlier session this morning has had a chance to transition over. Good morning and welcome to the final session of Bracewell's Spring 2021 Environmental Seminar. We're going to wrap up the seminar this year with a topic that is a top priority of the Biden administration and one that I'm sure you're seeing mentioned in the trade press, and that is environmental justice. I'm Whit Swift. I'm coming at you live from Bracewell's Austin office, and I'll be joined this morning by one of my Austin office colleagues, Daniel Pope, as well as Anna Burhop, who's a principal with Bracewell's Policy Resolution Group in Washington, D.C. Anna's got some fascinating and relevant background and experience for what we'll be talking about this morning in these environmental policy issues. She spent many years serving on the U.S. Senate Committee on Environment and Public Works on behalf of a couple senators, and was also the Environment Director of Regulatory and Technical Affairs for the American Chemistry Council. Daniel and Anna, thanks for joining me this morning. And to all of you in the audience, thank you for joining us. Our plan is to spend the next 45 minutes discussing some different environmental justice issues that we've been tracking and thinking about. And we'll then open it up for some questions and discussion at the end. If you have a question that comes up, you can enter it in the chat function there on your screen. I've spent the past couple of decades representing folks in environmental permitting matters and enforcement matters. But the fact is, while I've been aware of environmental justice and you read about environmental justice, it's really not been an issue that I've dealt with directly. It's not a foreign concept. It's been out there, but in my view, it really hasn't been a key factor in enforcement cases or a significant element of permitting matters. My practice is primarily air permitting, but I suspect that many of you on the phone are in the same boat. And I also suspect that a lot of us feel like that's going to change. The current administration has been very clear about its intent to end this era in which environmental justice is an aspirational concept or an ideal and turn it into something that will have teeth. And that's what we're going to talk about this morning, how the administration plans to do that and how that might affect the members of the regulated community. One such area is enforcement. EPA's laid out some plans on the enforcement front already, and I'll be talking about those momentarily. Another area where the administration wants to give environmental justice some teeth is in permitting, project permitting. We'll talk about that as well. And then in addition to those sort of administrative or executive branch concepts, Anna is going to talk about what's happening on the EJ front on Capitol Hill. We've got a lot more than 45 minutes worth of material, but we only have 45 minutes of your time, so we'll dive right in. I'm sure that you are aware, if you've been following the environmental justice movement and developments, that there was an executive order issued by the Biden administration earlier this year. We dedicated one of our Environmental Essentials webinar series to EJ issues back in January, I believe. And if you'd like some more background on environmental justice, I direct you to find that. You can find it on our website. What we're hoping to do this morning is spend less time on the background and more on what's happening and what we expect to happen as the agency works to implement this executive order, which was titled Tackling the Climate Crisis at Home and Abroad. And so while that order doesn't have environmental justice in its title, it's clear that the administration views environmental justice and climate issues as intertwined, and it directs EPA to take a number of actions that, if as I look at them, they're not going to be tied to simply climate change or greenhouse gas emissions, but rather, will have much broader effect. Most relevant for my part of our discussion this morning, the order directs EPA and DOJ to strengthen enforcement of environmental violations that have a disproportionate impact on underserved communities. It also directs EPA to create a community notification program that will monitor and provide real-time data on pollutants affecting fence-line communities. One other aspect of that order that I think is worth noting, in particular for these topics, is the direction given to the Council on Environmental Quality, or CEQ, to develop this climate and economic justice screening tool. This is a tool that will build off of EPA's current EJ screen to identify disadvantaged communities. And I think of this as a, I guess, it will affect everything in the environmental justice world. That is, if EPA is going to take steps to focus enforcement on sources or facilities that are located near disadvantaged communities that deserve protection under environmental justice, well, how you identify those communities is going to be an important issue. So I do think that screening tool and what it uses to identify the communities that are deserving EJ protection and the scope and size of those communities is going to be a really important issue, because again, it will bleed back into all of the substantive implementation of EJ directives by the agency. The Biden executive order contains a lot more than that, but those are the key directives it gives relating to EJ that could directly impact the regulated community, at least from an enforcement perspective. And given that that's what I'm talking about here this morning, I'll leave it there. And again, if you want to learn more about all of the items covered by that executive order, I would send you to our website to look at that past EJ webinar we did. So now, keeping the mic here at my desk, talk a little bit more about the steps that EPA has recently taken to fulfill this directive to strengthen enforcement for violations that may have a disproportionate impact on environmental justice communities. First was just in early April, EPA Administrator Regan directed all offices to strengthen enforcement of its, quote, cornerstone environmental statutes in EJ communities. The selection of the administrator was seen as a win for EJ advocates, and that I feel like has been confirmed by the statements he has made and the actions that EPA has taken in early 2021. But here you had, again, a signal from the EPA administrator saying, okay, we want to strengthen enforcement of our bedrock basic Clean Air Act, Clean Water Act, Clean RCRA statutes that affect EJ communities. The next and more recent step was a memo that the OECA Assistant Administrator Larry Starfield issued titled, "Using All Appropriate Injunctive Relief Tools in Civil Enforcement Settlements." Now, those of you listening here in Texas or other Region 6 states, Larry Starfield will be a familiar name, as he spent many years at the EPA Region 6 office in Dallas. And here he is writing these memos as the acting assistant administrator in OECA. But that April 26 Starfield memo directs EPA Enforcement Office representatives in the different regions to look at compliance tools that will be most effective in ensuring facilities will return to and remain in compliance. Now, it's not an EJ specific memo, but the compliance tools that are mentioned, specifically the types of injunctive relief in the memo, are clearly the type of measures that you would expect EPA to employ in enforcement cases that have a real environmental justice focus. The tools that the memo directs the regional offices to consider include advanced monitoring. So there you're talking about going beyond the monitoring that is required by rule or permit. So you're looking at both, not only maybe monitoring at the source or the discharge, but EPA talks about, ambient monitoring, fence line monitoring requirements. Second element is increased public access to compliance data. That is, whether it's from advanced monitoring or traditional monitoring record keeping, getting that data more directly to the public. It also recommends that OECA consider third-party compliance audits as part of settlement agreements to provide this independent verification of compliance to the public. So, there are these, frankly, aggressive tools that EPA is saying, okay, we want you guys to look at in fashioning settlements in enforcement cases. We want you to look at these tools in issuing those or in writing up those CAFOs. The memo also directs OECA to seek injunctive relief to address past harm caused by noncompliance or otherwise to benefit the communities that were impacted by that noncompliance. And here they talk about using, or I guess returning to the use of supplemental environmental projects that go beyond compliance to benefit those communities. It also recommends that EPA seek mitigation. And those are actions not focused on preventing future violations, but addressing harm from past violations. So you've got this early statement about, okay, let's focus our enforcement of traditional statutes on sources that impact EJ communities. Then you've got this memo that's come out saying, hey, let's think about all these tools that we have to use in the enforcement context. And then most recently on April 30th, OECA issued another memo that as I look at it, combines this directive of focusing enforcement energy on EJ communities and looking at all, looking at all these tools that we have to achieve compliance and to try to make achieve tangible benefits for EJ communities that could have been impacted by noncompliance. So this new memo on April 30th is titled Strengthening Enforcement in Communities with Environmental Justice Concerns. And it identifies specific enforcement program goals to address EJ issues. Those are increasing the number of facility inspections in overburdened EJ communities, and then also using these remedies that were discussed in the earlier memo that might have tangible benefits for the community. Talk about what they call early and innovative relief, which would be fence line monitoring and data sharing, the use of SEPs. And in addition to that, the memo urges OECA folks in the regions to think creatively about how to use all their available tools to craft settlements that might address past harms in communities. It also directs OECA to consider interim measures. So things like an administrative order or preliminary injunction that might stop compliance or expedite the implementation of a remedy. It also directs OECA to increase its engagement with the community. So, these are again, reinforcing, not only directing OECA to engage with the community as part of the enforcement process, but also reinforcing this, everything's on the table. Let's think creatively about the tools we have, and let's see what we can get in resolving these enforcement cases to make a difference. Last, and I think this is a real interesting one, particularly for folks that have sources or operations in states that might be slower to take up the EJ mantle, is the memo describes environmental justice as a shared concern with partner agencies and co-regulators, and states that OECA should not hesitate to step in and take necessary action if a community's health may be impacted by noncompliance and EPA deems that the partner agency is not taking timely or appropriate action. So I think there's another signal that, even if you're located in a state that may decide to either not act on environmental justice or is implementing a program that is moving more slowly or just applies those concepts or feels like it's addressing those concerns in a different way, here's a signal that I think, we might be looking at an era of additional overfiling or EPA, stepping up enforcement, at least when it comes to sources that impact EJ communities. So, again, the administration is taking it very seriously. EPA, the enforcement office at EPA is taking it very seriously, and they're doing what the executive order told them to do with regard to beefing up enforcement in EJ communities. And again, these memos, they aren't about new tools, but rather reminding OECA, okay, these are the tools that we have. Let's use these existing tools to further this directive and move forward on environmental justice issues. This is all very new. These memos just came out in late April, but there are already some examples where you can see EPA pursuing these new, creative, aggressive remedies when you've got an enforcement case that has an environmental justice overlay. With that, in order to not hog our time, I am going to pass the baton to Daniel for a few moments to talk about this other aspect where I really think you see environmental justice, the potential to directly impact folks, and that is, project permitting authorizations and looking at EJ concerns in those analyses. If we have time at the end, we can talk in a little more detail about the couple examples where we've seen EPA using, creatively using tools in resolving enforcement cases aimed at addressing EJ issues. But with that, here, let me hand it off to Daniel. I know that you've worked on some projects that have had environmental justice issues come up and have been doing some thinking about this. Why don't you tell us a bit about, sort of lessons learned and what you've read about how you think environmental justice is going to impact project siting and project permitting under this administration?
Well, sure, Whit, and thanks, Anna, for getting to be with y'all. First thing I think I'm going to do, Whit, is actually steal a couple of themes that you brought up in the enforcement context, and just let everyone know that they're also going to apply when you're seeking an agency authorization. The first thing that you said, Whit, that I want to emphasize is that, you brought it up in the enforcement context, but a lot of what we're seeing with environmental justice from the administration now is not just about addressing impacts that are attributable to a project through mitigation or something, but also using that review or that analysis to address past impacts that might predate an operator's presence in an area. So I think that's a huge theme that will kind of unite both of our remarks. And the same thing is true for using existing tools to accomplish environmental justice related ends. So I think we're also going to see that in the agency decision making and project authorization context. So environmental justice is fascinating and it's complex, and it relates to human health, economic activity, and the legacy of racial injustice in this country. Any one of those topics spawns, thousands of PhDs a year. So we can't really address all of it in one seminar session. So what I want to do for our time here, as we're thinking about agency decision making and how environmental justice might shape agency decision making, or affect a project authorization or permit, I just want to kind of distill this big topic into three buckets. The first bucket is how environmental justice might affect the process of getting a permit The second thing I want to look at is how the substantive provisions of a statute might be used in new ways, going back to what was talking about using existing provisions in new ways, how substantive provisions of a statute might be used to consider environmental justice. And then third, what NGOs are doing right now on the environmental justice topic, motivated by environmental justice, to explore new claims, to explore new legal theories. So for the first topic of how environmental justice might affect agency decision-making in terms of process. In the context of project approvals, you're usually dealing with the National Environmental Policy Act, NEPA, which mandates that you consider environmental impacts and impacts on the human environment. One of the ways that NEPA accounts for environmental justice and brings environmental justice into its review of what kind of impacts a project has is through the evaluation of socioeconomic impacts on existing communities. This is not new if you've been in the NEPA world at all. These kinds of environmental justice impacts, or in sort of an environmental justice review, has been around since the 90s, maybe even before then, but certainly we have the Clinton Environmental Justice Executive Order in 1992. That's something that we may already be familiar with, and is certainly the executive orders that Whit was just mentioning draft on that. When you consider environmental justice in the context of NEPA, it's a function of process, not of substance. And what I mean by that is that quite famously, the National Environmental Policy Act doesn't mandate a particular outcome of an agency's decision-making process, right? So the agencies that are undertaking the preparation of an environmental assessment or an environmental impact statement are not required. I should probably hang up that phone. I'm getting a wireless call. As you know, modern, we're doing it live, people. We're doing it live. Anyways, back to NEPA and not being interrupted. When agencies are considering environmental justice in the NEPA context, Whit, was that you calling me, by the way? Were you kind of doing that to mess with me? Anyways, when agencies are considering environmental justice in the NEPA context, y'all know that NEPA doesn't mandate an outcome. So there could be an environmental justice impact, and it might not really shape the outcome of the agency's decision. And that's especially true if there are a limited number of factors that agencies are basing their decision on. And so, so that evaluation, that procedural evaluation, is something that we all want to see agencies, when they're reviewing our projects, go through NEPA, and to do it in a way that's defensible in litigation. Because whenever we're talking about agency decision making of significant projects, we're also talking about we're also talking about administrative litigation against whatever authorization you receive. And so we want to make sure that they follow through with their procedural requirements, but again, no substantive outcome is mandated. Moving to the second bucket, what I described as sort of the substantive elements of agency decision-making and permitting. One thing that's interesting to me, and one thing I think that we will see challenged more and more, we're already seeing it, and we're going to see it in the courts more and more, is how the substantive provisions of a statute that relate to public interest, or, if you practice before FERC, public convenience and necessity, those kinds of broader statutory factors that an agency has to make a finding regarding. It's going to be interesting to see how environmental justice advocates start to use those kinds of public interest-oriented statutory provisions to challenge a project. Another one that I've seen, not just under the Natural Gas Act, but under the Clean Water Act, when the Corps issues a Section 404 permit, it usually has to make a conclusion that a project is in the public interest. Well, what's the public interest? What do you review when you're trying to make a decision about whether a project is in the public interest or not? I think we're going to see renewed advocacy there from environmental justice advocates who will challenge a public interest finding and demand to see the sort of agency's record of its decision-making process and whether it actually considered environmental justice issues when a project is cited in a particular area. Now, I don't want to go on too long because we're going to get to the good stuff with Anna. But the third bucket I mentioned is environmental justice and NGO creativity. While Anna's going to talk with us about what's happening on Capitol Hill and what's happening at the White House, I think it's important to remember, as far as litigation is concerned and your project authorizations may be concerned, is that environmental non-governmental organizations aren't exactly waiting around for this administration to provide, their definition of environmental justice from on high so that we can all agree on it and that we can all understand what the playing field is. That's not how that works. And NGOs are exploring, as we speak, new ways to challenge projects that if you're an environmental attorney, you might not exactly be paying attention to, and you might be surprised if you see what I'm about to share. So, for example, NGOs are using the topic of environmental justice as a motivating theme or a galvanizing factor for community engagement to spur local opposition to projects. So, we're not talking about federal agencies issuing permits anymore. Some of you in Texas might remember that I think it was in 2014, the city of Denton banned hydraulic fracturing within its city limits. This was very controversial. The Texas legislature responded saying, no, you can't do that. But I bring that up to illustrate how topics like environmental justice, which wasn't in play in Denton, but is motivating other challenges, other local challenges that we're seeing, how it might galvanize a city council to adopt an ordinance that at least impacts your timetable, even if you know that a legislature might change it or a court might not uphold it. Another interesting thing we're seeing related to NGO creativity around environmental justice is the use of Title VI of the Civil Rights Act. And so if you're not familiar with Title VI, it provides that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in or be denied the benefits of or be subjected to discrimination under any program or activity that receives federal assistance. And most of the agencies that we deal with, even state agencies, are receiving some kind of federal assistance. And so Title VI applies to their decisions. We're seeing now that NGOs are challenging projects using Title VI when a project receives an authorization from a state agency. This has happened in Missouri, where I believe there it was an interim operating permit that issued out of the Missouri Department of Natural Resources. That was challenged by a non-governmental organization when it filed a complaint with EPA's Civil Rights Office saying that the agency's approval of that interim operating permit constituted discrimination. We're seeing that in Michigan, where the Michigan Department of Natural Resources issued a PSD permit. Environmental justice organizations filed a complaint with EPA saying that the issuance of that decision or of that permit showed that the state agency was violating its Title VI obligations to ensure that its funds were not used in a discriminatory fashion. So there's a lot of development happening in both the procedural, the substantive components of statutes, and then we're also seeing a lot of creativity coming from completely new tactics that the environmental justice community is bringing up. So before I just pass it off to Anna, sort of what can you do about this? What can you do when a new area of law is emergent the way that environmental justice is, and at the same time is kind of unclear, and the doctrines surrounding it are undergoing development? I think the first thing that any project developer can do is begin developing institutional and company side skill with the topic of environmental justice. And that is also going to include developing skill at engaging the real stakeholders in a community. Engaging the community itself, you're going to learn what that community wants, and that's not always the same at what project opposition might want. And so it's really valuable to engage communities and learn from them what is meaningful as far as environmental justice goes. You can ensure that an agency is adequately considering environmental justice topics as you go through the decision-making process with them. And you can make sure that that's documented in a way that's defensible in litigation. Going through both of those steps, I think, will also help you when the fight over what the narrative of your project is. You can either write that story yourself and make that a big part of defending your project, or you can let people that might be opposed to your project write it for you, and that usually doesn't work out particularly well. So those are some quick takeaways. Love to develop those further with you, but now I'm going to pass it off to Anna, who's going to give us the update from DC.
Great, thanks guys. So there were a couple of things that I did want to add on to our administration discussion, which is, we talked very briefly about the White House Environmental Justice Advisory Committee, which is not the same thing as the Interagency Task Force. Since I think most of you guys have probably seen the report that came out, their suggestions that they sent over to the White House, which I only bring it up because, what they did buried inside that very, very long report, 90 pages or something like that, was they specified certain technologies and market mechanisms that we talk about a lot, that the administration has been talking about a lot, like carbon capture, carbon trading, nuclear energy, hydrogen, things like that, don't qualify for conferring enough benefits to environmental justice communities. They also didn't talk about, how you define these benefits. Daniel just talked about, there are a lot of things that the administration has not done yet, besides defining environmental justice specifically, but also they talk about needing to confer 40% of benefits of clean energy projects to these communities. But nobody has any idea what those benefits look like, what they mean, how you confer them upon communities. So that's up for debate. But I only wanted to bring this up because the report did receive some mixed reviews from the administration. And I know it gave a lot of us a little bit of heartburn when we first saw it. But the one good thing that came out of it is the White House domestic climate czar and our former EPA administrator, Gina McCarthy, very quickly, like within 12 hours, the next day, came out and reassured everybody that the administration is still supportive of the technologies that were criticized in this WEJAC report. So I just wanted to say that because I know that a lot of folks are talking about it and a lot of people are spending a lot of time on that specific report. And I don't know that we need to do that. I'm not sure it's really worth your time and the heartache that it will probably bring up. So there are other places besides these executive orders that the Biden administration has been including environmental justice considerations. The first thing is the American Jobs Plan. For those of you guys who work on infrastructure, I'm sure you are aware and probably very familiar with the American Jobs Plan. Again, most of what we're looking at here is an effort to address historic inequities. And eventually the focus will turn to, preventative measures. But right now, a lot of it is sort of backward looking, and how do we make these communities whole? So in the American Jobs Plan, there's $20 billion for a new program that will reconnect sort of previously isolated neighborhoods, like they don't have a highway exit or something along those lines. Clean energy block grants and, economic development efforts that are specifically for community-driven environmental justice efforts. Things like Whit and Daniel have talked about, like capacity and project grants for legacy pollution, cumulative impacts for frontline and fence line communities, and things of that nature. And again, this also has the 40% of benefits of climate and clean infrastructure investments have to go to disadvantaged communities. But we still don't know what the 40% actually means. The American Rescue Plan, which is more of the president's social or human infrastructure plan that goes along with the infrastructure plan of the American Jobs Plan, includes, again, more funding for some of these things that Whit and Daniel talked about. $50 million for EPA to monitor air quality, so that they can identify the communities with the highest pollution. And then a couple of stranger things, not strange, but just not directly environmental justice-y, but is still sort of considered part of that, which is the Department of Health and Human Services gets a significant amount of money to help families pay their water bills and their energy bills. So these are just examples of things that the administration considers environmental justice. You'll see as we keep talking, the concept gets broader and broader and broader. So the president also had to include some funding requests for all of these new programs that I sort of mentioned, and there are a lot more. We just don't have enough time for it. In his discretionary budget request that he sent to Congress, because as we all know, Congress holds the purse strings. And while it's great for the administration to put out these broad goals and plans, it's really up to Congress to actually implement them and fund them. So in his budget request, he asked for a couple $2 billion worth of money specifically for environmental justice. And I can go through those in more detail later if people are interested. But I think really what would be most interesting in the 5 minutes that we have left is looking east down Pennsylvania Avenue to Capitol Hill. So congressional action traditionally, when it comes to environmental justice, is not as overt or comprehensive as we're seeing come out of the administration and the federal agencies. Some of that is because the environmental justice doesn't really have a home in any environmental statute. It's sort of been housed in NEPA, which Daniel talked about, but it doesn't officially have its own home. The other reason is likely because, like I mentioned before, most of the current focus is on addressing historic inequities, and Congress doesn't do a whole lot retroactively for a variety of reasons. There are exceptions to this rule, but generally they don't do a whole lot backwards facing. And also the environmental justice movement, as again, we've discussed already in the last hour, they don't have hard and fast pillars so far that can be easily used as the basis of new legislation. However, like Daniel mentioned, that's changing, and advocates are pushing more and more for concrete actions to be implemented, like direct investment in disadvantaged communities, mapping communities and their pollution burdens, massive investments in drinking water infrastructure, ensuring that climate rules benefit the low income and disadvantaged communities. And then also, as we are seeing day in and day out now, that there's a desire to condition permits and increase enforcement. But so Congress is sort of getting much more involved than they have been. I worked at the committee that had jurisdiction over environmental justice for almost a decade, and we had a couple of hearings on it, but it was never something that came up regularly. I've been gone for 4 years now, but things are changing. And now Congress is turning their attention to the environmental justice movement. And I think one of the primary reasons, not just because the administration cares about it, but like what Daniel mentioned, the community activists, the ENGOs, people back home are making a really, really big splash. You know, they're interfering with projects. They're, they're impacting our day-to-day business, and it's getting a lot of attention back home. And members of Congress and their staff pay a lot of attention, rightly so, to what's going on back home. So these, traditionally very grassroots, localized movements are now having a very significant impact in what is going on here in DC. So just a couple of examples, and I'm going to go over a little bit, so I apologize. The House has an environmental justice caucus that has recently been activated. It's co-chaired by the Natural Resources Committee Chair, Raul Grijalva from Arizona. He spent a lot of his time over the last couple of years developing the Environmental Justice for All Act. It's been recently reintroduced this Congress, so it is an active bill. But the reason I bring this up is because it was originally introduced last Congress, and the Senate lead was our vice president. So this is just something that is, again, I think worthy of knowing about because of Vice President Harris being involved with it. This is really the only environmental justice focused bill, and it, requires agencies to consider cumulative health impacts under the Clean Air Act and Clean Water Act when making permitting decisions, and ensures that permits won't be issued if projects can't demonstrate basically no harm to human health. It strengthens Title VI of the Civil Rights Act, which Daniel just talked about. And then it also provides significant monies into grants for research and program development to basically address historic environmental justice issues in communities. It also sets up a whole new assistant fund that is based solely on fees from oil, gas, and coal companies. So there's always a little bit of partisan issues in some of these bills. And I know that's a lot, but I will say the bill did not make any progress last Congress, and it still remains to be seen, even with a Democrat majority, how much progress it could make this Congress. So, and again, like I said, the solely EJ focused bill is very, very rare. I think this is really the only one. But what usually is happening these days is when Congress is working on a larger legislative package, there will be an environmental justice provision somewhere in that larger package. For example, we've got the Clean Future Act, which is a House bill And it includes that environmental justice has to be a part of all of the federal agency missions, and that environmental justice considerations must be incorporated into landmark environmental laws. So remember how I said earlier that EJ doesn't have a home? Congress is trying to change that so that it's easier to regulate and enforce. It also sets up some grant programs. Everything EJ focused sets up grant programs. This one specifically is for allowing impacted communities to participate in permitting and regulation processes, but specifically for petrochemical and hazardous waste disposal facilities that may be in their neighborhoods. And the last thing that I'll mention is, so I work on plastics and recycling issues as well. And the biggest legislative package that has been reintroduced this Congress is the Break Free from Plastic Pollution Act. It also has a provision that would basically prevent any new permits to be granted for new plastic manufacturing facilities or an expansion. So no permits for any of that until NAS and NIH can conduct a study on the environmental justice impacts of the entire supply chain. So I will say, for anyone who may have gotten a little bit of heartburn from what I just talked about, remember the legislative process, it's very, very lengthy, and there's no easy, quick path for any of the bills to make it to the president's desk. So just two things to say in wrap up, which is basically why should you care from the congressional perspective? It's important to keep it on your radar because we're seeing increased momentum. Agencies are implementing the requirements in the administration's orders. We're seeing a lot more enforcement, permit conditions. Capitol Hill is activating their environmental justice caucus. They're introducing more legislation. But then also what Whit mentioned at the very beginning, and I think Daniel mentioned as well, is environmental justice is a huge component of the climate change conversation. And climate change is obviously a huge priority for this administration. And I say this because they have two climate czars, not just one, two. So between an active, engaged Congress, the focus of the White House, EJ is going to stay top of mind for folks in DC and obviously across the country. So, all right, I'm now way over. So Whit, I'm going to turn it back to you.
Sure, thank you, Anna. And as a lawyer who does a lot of permitting, it's fascinating, if not headache-inducing, to think about how those environmental justice and cumulative impact demonstrations might be incorporated into the permitting process should this should legislation like that move forward. Just a fascinating topic. We did go over a couple minutes. We are going to transition to overtime here to answer any questions and maybe hit some other topics that we couldn't fit in our window. But thank you, all of you, for joining. I hope you found this both interesting and helpful. Before we transition to Q&A and to talk about some examples, I do want to alert everybody on to our next series of webinars that Bracewell's hosting next month. June will be ESG month at Bracewell, and we'll be hosting 3 separate webinars on environmental, social, and governance issues. They will be on June 15th, June 16th, and June 17th, a similar sort of 3-morning format to what we just used for this virtual environmental seminar. So again, please join us for those 3 days in the middle of June, and they will turn you into a pro on ESG issues. All right, well, with that, let's transition to see if we have any other questions, any other topics. There were a few things that I wanted to get to. I'm going to sit here and look at Daniel or Anna. Perhaps you're more savvy than me and can let me know if there are any questions that come in that I need to answer. there were a couple things. If we don't have one right now, I'll ask and answer my own question, or at least give some examples. I referenced some interesting aggressive uses of kind of injunctive relief measures that we've already seen from EPA in the enforcement context. To flesh that out a bit, there were two specific examples that we've seen, and each really fascinating in its own right. One, both have gotten coverage in the trade press, so you may have seen these. But one was this Lime Tree Bay refinery that's located in the Virgin Islands. This was a refinery that had long been idle, and it was restarted. I think starting a year or two ago, they started bringing it back on, and they've continued to bring it back on. But they've had a slew of environmental issues, primarily air emissions related, in conjunction with starting this refinery back up. Lots of releases, flaring events, and events where they had, your worst case scenario of the flare apparently not combusting everything that was being sent to the flare header, and raining down liquid droplets, oils raining down on the neighboring community. And here, what you see EPA using exactly those tools, and this, I think the order came out 2 weeks ago. EPA using exactly the tools that were discussed in one of the Starfield memos, where they issued a shutdown order for this refinery, basically saying all operations cease at this refinery until this order terminates or EPA says operations can resume. It's a 60-day order, and it then directs the owner operator to go get a third-party audit completed within this 60-day period. All these restrictions on the auditing, like the auditor cannot provide the owner operator with any draft report or anything. Basically, EPA gets to see the raw findings of the auditor at the same time as the owner operator. But they've got this 60-day period to go in, get this audit done, to try to, identify ways to prevent future non-compliance. And again, it's a shutdown order, and that these steps have to be completed in order to get back to resume their operations. I mean, this is an extreme case, and I think there's a lot going on with this particular site. But there you go, an example of how seriously EPA took on these repeated events. There was an environmental justice component based on the impacts to the neighbors, fence line community. And here was, this is about as extreme a measure as I think you could imagine, as far as EPA, taking action in an environmental justice context. The one other is a project that actually our colleagues have been involved in, and to me, it's got a real interesting EJ angle. And a different aggressive use of, again, EPA's existing tools, but it's enforcement at a chemical site, chemical manufacturing plant. There are EJ concerns in the area. It's a big EJ driver, and in this, EPA is very aggressively taking a really aggressive approach on its use of its information gathering authority under Clean Air Act Section 114. They're actually seeking that the company conduct monitoring, ambient monitoring at the fence line, and provide that information to the agency as part or under the authority under Clean Air Act Section 114. Those of you that have been subject to 114 requests and think about this traditional, requesting records that you keep or that you're required to keep under, the Clean Air Act about your compliance and operations. And I know when I've worked with folks on 114 requests in the NSR context or the flaring context, there were, concerns about, okay, well, EPA, we feel like you're exceeding your authority because you're requiring us to perhaps create a record that we don't have. Well, to me, this blows well beyond that, where you've got EPA not only, this same information gathering saying, okay, under this, we're going to direct you to go out and actually conduct monitoring. and our authority for making you conduct this monitoring is our Clean Air Act 114 Information Gathering Authority. Really interesting stuff, and I think it just shows when you've got this emphasis and interest at the very highest levels of EPA and these directives coming down from the head of OECA to use every tool available and to think creatively about how we can leverage those tools we have to assist in the enforcement context when you're dealing with an EJ community. There's some examples of EPA doing it. I guess in some ways transitioning over to the permitting stuff that Daniel was talking about, there's a case out there, and again, you likely have seen it in the trade press, but there was and I think it has some of the same kind of interesting to see the emphasis from up top at EPA, but it's like a steel scrapping recycling plant in Chicago that has some EJ concerns, and it had gone through permitting and received I think its key, federal, or I guess delegated or state SIP approved environmental permits last year, is getting additional local permits from the city of Chicago. And you actually had the EPA administrator send a letter to the mayor of Chicago saying, you should pause this permitting process to conduct a thorough environmental justice assessment before giving this operator the local operating permit that it would need to conduct business at this site. Again, it's one that made it through, at least what you traditionally think of as the big permits, as far as the air permits and whatever, to the extent it needed discharge permits or anything else to operate. But at this local permit level, you've got the EPA, not necessarily using one of its levers under the Clean Water Act or the Clean Air Act to seek to address environmental justice concerns, but actually just pressure a letter from the EPA administrator saying, we're concerned about this. You, permitting authority, need to look at this. And if this would have come through last year, we would have recommended that these considerations be reviewed. It's interesting because to me, it illustrates a couple of these themes that we've been talking about here, which are, one, this idea that EJ in some ways kind of lacks a home. Here you have EPA, there's this, the lever that they've pulled is just basically public pressure, sending a letter to the mayor of Chicago, who, who's going to be in charge of this local permitting authority. There wasn't a legal hook to it as much as just a pressure to say, hey, we need you to look at this. And even in the letter, the EPA states that we would have recommended having these, having the Illinois EPA look at this if this permit was going through now. And I think that also shows an interesting issue on some of this EJ stuff about the state-federal relationship, and again, kind of the lack of hooks, clear hooks in the permitting process, in the permitting processes as they exist now to address EJ concerns. In the air permitting field, if you've got EPA concerned about something, but it's a state delegated or a state approved program, EPA is a commenter and they can weigh in, but that's really what they are. Unless it gets to the real extreme case where EPA might seek to object to an operating permit under the Title V program, in many ways, I think EPA, under the current statutory and regulatory theme or scheme, lacks some of the tools or the hammers that it might need to really push these issues. But there are some really interesting sort of case studies out there about the agency aggressively pursuing, aggressively using what it's got to try and push EJ concerns and to push for the protection of environmental justice communities. Anna, Daniel, was there anything that you glossed over in the interest of time that you'd like to add or discuss?
I don't necessarily have a lot. I don't see any questions though from the folks who are still on the line. I don't know, Daniel, if there's anything else you wanted to add.
I think if we started that up, we would be here for hours.
I know.
Talking about how multifaceted environmental justice is. But I'm sure our listeners will be overjoyed to know that we're going to, keep tabs on developments in this area, and we'll alert them to things as they happen.
Oh, one other thing is I do think you guys both talked about, what can I do? And I handed off to you, Daniel, before kind of talking about that as like, okay, well, from the enforcement context, what can I do to prepare myself or to reduce the risk of EJ concerns biting me in the enforcement context? And I think while I didn't address it explicitly to kind of wrap up my part, I think it's the answer is largely the same to what Daniel and Anna both discussed. Stay engaged in following these developments. I do think you assess your risk by you looking at your operations and see who they impact. Look at that EJ screen tool that EPA has and see where the communities that it identifies, and be aware that a more robust tool for identifying EJ communities is on the way, and follow those developments. But, look at, okay, well, who do we impact? If you're responsible if you're in a corporate office and responsible for multiple sites, figure out which one of those are going to be the biggest EJ risks for you. And then you think about, okay, I think as Daniel, as you mentioned, engaging with, to the extent that you haven't, or to engage with, if you haven't, engage with those communities or look for opportunities to do so. Because I think, clearly there's this angle of those folks exerting pressure themselves and on the permitting side. But then you've also got this clear statement from EPA about its direction to its folks in the field at OECA engaging local communities in the enforcement context, and that's whether you're talking about remedy, whether you're talking about just targeting sites that folks are unhappy with, that are going to be, perhaps more frequently or more vigorously inspected. But I think that type of engagement will, one, help you assess your risk, and two, perhaps minimize it to the extent that, you can head some of that off at the pass as far as engagement with, the community that the federal agencies or state agencies are going to look to when they want to see how you're doing vis-a-vis, this overburdened community that is on your fence line or nearby. So I think the what to do is somewhat similar, but in some ways that's nice because you're killing two birds with one stone. But I do think that the same things that will help prepare you, or at least minimize the risk of EJ haunting you in a permitting context, should also benefit you to the extent that there's this increased heightened focus on environmental justice in the enforcement context. With that, I guess let's wrap it up. Thank you again. Thank you all for joining us. I hope you enjoyed our spring 2021 virtual environmental seminar, since this is truly the end. Thank you for joining us, and we very much look forward to, fingers crossed, doing this in person this fall in Houston. I hope you all have a good day, and thanks again. Thank you, Daniel. Thanks, Anna.
Thanks, everyone.
Thanks, guys.